a little bit of an introduction first while people are still joining at 7 o'clock. So, good evening all. My name is Patrick Aaron. I'm the monitoring officer for both South Oxfordshire and Vale of Whitehorse. And I might have met some of you before. I've done some training for town and parish councils in the past. Something I like to do mainly so that so you know who you're dealing with, and really for me to be able to set out the way that we deal with code of conduct complaints, or maybe the way we want to deal with code of conduct complaints. So this training takes about an hour. It's I'd be grateful if you could turn your microphone off if you're not speaking, please, because this is quite sensitive, seems to pick up quite a lot of background noise. So about an hour, but that depends really, because if you have lots of questions, then it'll take a little bit longer. So feel free as we go through, please don't stand on ceremony, ask any questions, anything you want me to clarify, elaborate on, we can do that as we go. I can't see you. I can see a few people at the top of the screen because I've got my slides and my notes on the screen in front of me. So please just shout out if you want to ask me anything. So we're up to 40. That's a really good number. I wish I'd charged now, but there we are. So we'll get away without any further ado. So this session tonight is to introduce you to the new code of conduct. Those of you who've attended before will know that I take you through all of the different elements of the code of conduct. Tonight, I'll do that in some respects just to introduce the new elements, but I'll probably spend a bit more time than I would ordinarily on interest, because this is the big difference between the previous codes that you have worked to and the new code. So I know that some of your councils have already adopted the Oxfordshire Model Code. I know that some are waiting until they've attended the training before adopting, and some have decided that they're not going to adopt the Model Code, and that's perfectly fine. I'll explain a little bit about what the requirements are as we progress. So in terms of materials, there's a companion set of notes which are quite lengthy, but prior to every training session, I trawl the internet to try and find some of the worst examples of councillor behaviour so that it can bring these elements to life. Otherwise, it's quite a dry subject to try and convey. So I'll give you some of those examples as we go through, but clearly the notes are very lengthy, so I'm not going to go into them in any great detail, but you'll have them afterwards. You'll also have a copy of my guidance on social media. We'll also send you a flow chart to guide you through the new interests regime, and that's been taken from the LGA website. So thank you to them for that. It's a really useful aid memoir, all on one side of A4. You'll also have the slides, and we are recording the meeting, and we will make this available on YouTube. We had some difficulties. I had a session with clerks back in August to iron out any areas of concern, perhaps answer any questions. We weren't able to distribute the link to that, unfortunately, but this will be available on YouTube, so your colleagues, if they are unable to attend, will be able to watch it at their leisure. So as I say, really good turnout tonight. We're up to 44 members involved. I'd much prefer to do these in person, but circumstances being what they are, we're not able to do that. But nevertheless, gives me a chance to wear a shirt and tie, so I feel quite dressed up for a change. We don't get much opportunity to do that these days. So what's the purpose of the session? Well, it's to provide you with an update on the new model code. So we've adopted a new model code of conduct which has been agreed at an Oxfordshire level, and one of the reasons for that is we wanted to have the same code of conduct in place across all 3 tiers of local government in the county. It's based on the Local Government Association Model Code, but as you'd expect, when you get a group of lawyers in a room. They all want to put their stamp on the document. So there are some changes, and we've agreed that amongst ourselves as monitoring officers for county, city, and all of the districts. So hopefully, in due course, we'll all be working to one code of conduct. So the session tonight really is to give you an introduction to the code, explain some of the differences. I do like to provide examples as we go, and I mentioned in terms of the notes that we get. And as I say, the main focus tonight is going to be on the new approach to interests, because that is something I think which was lacking in the previous codes that we've worked to, and has led to some confusion in terms of what should and should not be declared. So any code of conduct under the Localism Act, it has to be underpinned by the Nolan Principles. And the Nolan Principles, I think, are probably ingrained in all of our consciousness as being members of local authority, and certainly as officers. They're equally applicable to us all. I've set them out there. I'm not going to go through them in any great detail. I think they speak for themselves. What I would say is that as part of our development of the model code, we have divided it into principles on the one hand and then obligations on the other, so that as members you are able to see very clearly what behaviours or activities may bring you into conflict with the code of conduct. So the Nolan Principles are exactly that. These are the principles. Sorry, something has gone awry here. Sorry, my slide has dropped off. Stephen, I don't suppose you've taken control of the meeting by any chance, have you?
No, maybe that someone else has. Can you take control? Try and take control back, Patrick, at the top. Or if people can check that they've haven't shared their screen.
No. Okay, bear with me a second. I'll just get it back. Are we back on, Stephen?
Yep, you are, Patrick. Yep.
Okay. Sorry about that. I'm not sure what happened there. So the purpose of the code of conduct is protect you as members and to guide you in terms of what model behaviour looks like. It's also to provide a check and balance. And I think fundamentally, one of the things I wanted to be absolutely clear about in the new code is that it tells you clearly what type of conduct could lead to action against you. I think fundamentally, as I say in the slide, it's about maintaining public confidence in the role of councillor. And in terms of guidance, you can have a look at the local government association guidance, which this code is based on, and it will give you some very clear indications in terms of each element of the code. So in terms of my experience, where are we with code of conduct complaints these days? I have to say, happily, we don't get that many. It's unusual to see serious breaches of the code of conduct. Generally, in my experience, they are interpersonal in nature, and as a result of that, sometimes relationships can deteriorate quite quickly. I think, really speaking, a lot of the complaints we have seen over the last couple of years have come through social media use. And when I talk about when the code applies, I think we have to understand that generally the councillors, as far as the public are concerned, are always councillors. Well, that's not the case. You're not councillors 24/7. So we'll talk a little bit about that. But one of the things I always comment upon with social media is that, you know, you have to keep a clear line between your official role and that of a personal viewpoint and personal accounts. But a little bit more about that in a moment. So, when does the Code of Conduct apply? The Localism Act says that the code that we have to adopt a code which shall apply to you when acting in your capacity as a member. Now, a lot of the time, that's very straightforward. If you're in a committee meeting, you're acting in your capacity as a member, and as a result, there's no question about it. There are other areas of your lives where your involvement in council business may come to the fore, and I'm sure that that there will not be many councillors on this call tonight who haven't been accosted whilst waiting for their groceries or waiting in the bank with somebody wanting to ask you about something going on in your patch. But as far as the Code of Conduct is concerned, when you're acting in your capacity as a councillor, straightforward. But if you misuse your position as a councillor, or you give the impression that you're acting as a councillor, and a reasonable member of the public with knowledge of all the facts would believe that you're acting as a councillor. And one of the things that I always mention in these training sessions is the case of Ken Livingstone. Now, Ken Livingstone was Mayor of London, as you know, and he'd attended a conference. It wasn't a conference, sorry, it was a social event in a town hall in London. And he was leaving, and he was approached by an Evening Standard reporter who was asking him for his viewpoint on a particular issue. And after a while, I think there was already some bad blood between Mr. Livingstone and that particular newspaper. And after a while, he lost patience and asked the journalist why he was harassing him, and basically he said, "It's my job." And he said something to the effect, "Well, what are you, like a concentration camp guard? Are you just doing your job?" And of course, the reporter then pointed out to him that he was Jewish and took offence to the comments that Livingstone had made. In essence, it went to the High Court because he was taken to the standards panel. It went to the High Court, and the High Court said that he was not acting in an official capacity when he made those comments. He was acting in an official capacity when he attended the event, but as soon as he left, he was a member of the public, and that was the thrust of the case. And what the judge said in that case, and you'll see this from the notes, is that it seems to me that unlawful conduct is not necessarily covered. Thus, a councillor who shoplifts or is guilty of drunken driving will not, if my construction is followed, be caught by the code, if the offending had nothing to do with his position as a councillor. So, quite clear there. Even that sort of conduct, which would be socially unacceptable. He then went on to say, though, that where a councillor might be performing his duties as a councillor or giving the impression he was, then the code might apply. And he gave the example of a councillor attending a restaurant, wanting to get a particular table, and in essence, uttering those immortal words, "Don't you know who I am? I can have your licence taken away." So, in those circumstances, quite clearly the Code of Conduct would apply, and there are some examples on the handout that I mentioned that. So, one in particular, quite close to where I live, a town councillor had gone into a shop to ask for trophies for an end of season presentation, I think at the local rugby club, and tried to negotiate a discount, and the shopkeeper must have been hard times, was having none of it, and again the council said, "Don't you know who I am? I'm a town councillor," and gave the impression that he could make things difficult for the shopkeeper. He was found to be in breach of the code and suspended. So as I talk through some of these examples, you'll notice that a lot of them are Welsh examples, and that's not because Welsh councillors are particularly poorly behaved, although the local report of the Public Services Ombudsman for Wales would say that their complaints have increased quite significantly. But the fact of the matter is that in England, we don't have a central reporting system. There is no standards board anymore, whereas in Wales, the local government ombudsman in Wales does actually publish decisions, and anything which is very serious is referred to the adjudication panel. And in Wales and in Scotland and Northern Ireland, there is the ability to suspend or disqualify councillors. That does not apply in England, and some would say that's a good thing, some would disagree, mainly because the accusation levelled at the standard system in England is that it has no teeth, and as a result does not really dissuade bad behaviour. Now, why is that, you might ask yourself? Well, the reasoning behind this was that everything should be dealt with at a local level, hence the Localism Act. And the government of the day decided that if a councillor behaved badly, then he or she would be judged at the ballot box, not by the Standards Board for England. Now, that's all well and good, and I slipped up once because I was moaning about the standard system to a colleague when I was at the Cambridgeshire and Peterborough Combined Authority. Anyway, long story short, he told me that he was a former civil servant who'd been involved in drafting the legislation which led to the situation we now have ourselves in. So note to self, always be careful, you never know who you're talking to. But what he said to me is, well, you know, it should be a matter of democracy. That councillor shouldn't be voted back in. I said, well, the thing is, that's all, you know, that might be all well and good in principle, but if somebody does something within a month or two of becoming elected, the public are not necessarily going to remember that 4 years on. So we are where we are. There aren't going to be any changes. The Committee for Standards in Public Life made some very clear recommendations which the government decided it didn't want to follow. So if you're acting in your capacity as a councillor, if you give the impression you're acting as a councillor, or if you misuse your position. And as I said, there are some examples on the companion notes. One I've dealt with, and I've actually given you a link to the decision letter in that case. Very difficult case. Some comments made on Twitter by a councillor at Stroud when I was there. But the only reason she was found to have been caught by the Code of Conduct was because her Twitter handle referred to herself as councillor, and as a result gave the impression that she was speaking as a councillor. In that case, very difficult case, I found no breach, and you can read the letter at your leisure in any event. But another example, when I was at Stockport, a cabinet member had made a derogatory comment about somebody on her personal Twitter account, but she was referring to something that had happened during the day while she was dealing with an issue in her role as a cabinet member, so caught by the Code of Conduct. So the public expectation, and I think our expectation of each other, is we should lead by example and behave according to the highest standards of personal conduct. But as I said earlier on, the public may not appreciate this, but you're not on duty 24/7. You are off duty when you're not acting in your official capacity. And one of the reasons for this is that the government view, what happened was the Committee for Standards in Public Life said, well, we would like to make it a rebuttable presumption that a member is always acting in their official capacity, and it's for them to demonstrate that they weren't. And the government said in response to that, it's important to recognise that there is a boundary between an elected representative's public life and their private or personal life, automatically presuming, irrespective of the context and circumstances, that any comment is in an official capacity risks conflating the two. So very clear dividing line. When I receive a Code of Conduct complaint, one of the first things I do is ask in what capacity that person was acting when the alleged conduct took place. So that's the starting point. If I take a view in consultation with the independent person that they were not acting in their official capacity, then that complaint is rejected at that stage. So what type of conduct is covered? Well, it's very broad, as you might expect. All forms of communication and interaction, face-to-face meetings, online or telephone meetings. But even though the code of conduct doesn't apply to you in your private capacity, all I would say is just be aware that behaviour in a private capacity can reflect on you in your role as a councillor, particularly in a small environment where everybody knows everybody. Sometimes neighbour disputes can spill over, and I've had complaints from somebody who believes that their councillor neighbour has acted unreasonably, clearly not acting in an official capacity, but as far as the neighbour is concerned, they're a councillor. So just a word to the wise there. As I said earlier on, the code of conduct is divided into two parts. The first part are general principles, but nevertheless very important. And as I already mentioned, the Nolan Principles apply across the board to us in everything we do in our working and professional lives. Very clearly, though, the obligations, i.e. those behaviours which may bring you into breach of the code of conduct, start at paragraph 6 in the code. So I'm going to start there and work my way through those one by one. So I'll pause there. Any questions on anything I've said thus far? Nope. Okay. So one of the first changes to the code of conduct is the concept now of respect. And there are two obligations here: that you treat everyone, including other councillors and members of the public, with respect. And then secondly, any local authority employees, representatives of partner organisations. So in terms of your environment, that would mean the clerk and anybody else employed by the council, anybody you bring in as a partner to do any project work, for example. So during the consultation on the Local Government Association Model Code, they did start to canvass opinions around the use of the term civility. It wasn't a popular recommendation. I think the general consensus was you can be respectful to somebody, but in terms of political rough and tumble, you might not necessarily want to be civil towards them. Now, it may be that we're dealing in semantics there, but what we've ended up with is respect. So that is clearly front and centre of any code of conduct that we have before us now. So what does respect mean? Well, it means politeness and courtesy in behaviour, speech, and in the written word. However, I'm bound to say that debate and having different views are all part of a healthy democracy. I completely appreciate that perhaps parish council level, they're not overtly political, maybe not political at all. But generally speaking, differences of opinion from a political perspective are perfectly acceptable. And whilst I'm not going to talk about it in any detail tonight, the code of conduct is subject to right of freedom to speech. And I did mention that the last time we met. And again, if there's ever any question of a breach of the code, that's one of the things I also apply and consider. So as a councillor, you can express, challenge, criticise and disagree with views, ideas and opinions, policies in a robust but respectful manner. But there's a fine line, and councillors should not subject individuals to personal attack. And in your contact with the public, you should treat them politely and courteously, because rude and offensive behaviour lowers the public's expectations. However, it's a two-way street. You know, you are not fair game as councillors. You know, you should not have to put up with bad behaviour from members of the public. And particularly in a council forum, officers, so including clerks, any other employees of your council, generally if there's an issue with a clerk, you should take it up with the chair, or if you have a staffing committee, with that committee. What we shouldn't be doing really is having criticism of officers in a public meeting, mainly because officers are not in a position to speak up for themselves. So if there are issues, take them offline, deal with them through the proper channels. But as I said, if you are subjected to abuse by members of the public, well, quite clearly you're within your rights not to have any interaction with that person. The other thing I would mention as well, a bit of a plea, I think, from some of your district councillor colleagues. They appreciate that you have a very careful agenda in terms of your local imperatives and what is important to you locally. District councillors come as your guests and they give you an update on what's happening. I think I've had 1 or 2 complaints from district councillors that they feel that they've been subjected to quite unfair criticism and conduct from certain parish councillors. And I would just say, again, they are your guests at these meetings, and just please treat everybody respectfully. So respect is linked to disrepute. As I say there, where is the line drawn? It's a rhetorical question. As I said earlier on, healthy debate, disagreement is fine. Personal attack crosses the line. As I say there, it doesn't prevent what I call political rough and tumble. It's all part and parcel of political life, even if with a small p. And politicians, and that includes town and parish councillors as well, are all entitled to an enhanced protection under the freedom of expression rules. Just be careful. I mean, there's a difference between being ironic or perhaps being sarcastic about something to make a point. When it crosses the line into personal attack, that's when this line will be crossed and you will be potentially in breach of the code of conduct. And as I said earlier on, it works both ways. You're entitled to respect as well, and interaction with district councillors and parish councillors. So I've already mentioned that. So the next element is that of bullying, harassment and equalities. Most of this you would think speaks for itself. The Committee for Standards in Public Life were concerned that there was no definition of bullying in any of the codes of conduct. So we now have the ACAS definition of bullying, which is now forming part of the code of conduct. So that is quite clear. That is a definition. It's a matter of degree always, depends on the behaviour complained of. And as I said earlier on, sometimes a lack of respect can cross the line. I would say that there must be a course of conduct. It's unlikely to be found to be a breach on one example, but that very much depends on the conduct complained about. Harassment, the definition of harassment is also now included in the Code of Conduct, and that's taken from the Protection from Harassment Act of 1997. And essentially that's conduct which causes alarm or distress or puts people in fear of violence. As far as the law is concerned, course of conduct is more than one occasion. I think we're also in the public sector acutely aware of our duties to promote equalities. Now, this is quite a wide-ranging requirement. I would take quite an objective viewpoint of this, that shall promote equalities, I would say, is to do your best. I wouldn't find somebody in breach of the code of conduct, for example, for not actively being promoting equality. So it's that sort of situation where somebody might put something online which crosses the line and could be considered to be contrary to the Equality Act in terms of the protected characteristics covered by the Equality Act. And the Stroud case I mentioned earlier on, when you read that, if you read it, you'll see that the complaint was the councillor had put something on Twitter in the heat of the Black Lives Matter disturbances in London. If you remember, during the first lockdown, I think it was, there was a gathering in the town centre in Stroud, and somebody had been speaking about the Black Lives Matter movement, and one of the councillors had gone on to say, yes, I understand what you're trying to do, but we're in the middle of a pandemic. We shouldn't be gathering in a public place and spreading coronavirus. So there was, I think they call it these days in social media, a bit of a pile-on. So everybody sort of jumped onto that comment and took great exception to it. But one of the complaints I had is that she placed the council in a position where it was in breach of the Equality Act, and of course she hadn't. I found as a finding of fact that she hadn't actually made any comments which could be deemed to be contrary to anybody with a protected characteristic of race. But I also found that even if that were the case, that she was entitled to freedom of speech in that circumstance. So it does get raised, and I would say rarely. I don't very often get complaints about equality. I think thankfully, because we all pretty much know exactly where the law is and where society is in relation to what is right and what is wrong, unless you're a certain MP at a certain conference when you make a comment like that, and you saw the news last night about the reaction. So people are very tuned into to equalities, and rightly so. So the next element is that of that shall not compromise or attempt to compromise the impartiality of anybody who works for or on behalf of the local authority. So generally speaking, that is trying to get somebody to do something that would not be correct, abusing your position, putting pressure on somebody to do something which was not appropriate. Thankfully, again, I don't get any cases like this. I haven't had one for a long time, but there is a fine line between having a very strong view about something and then trying to force that view onto officers, and particularly at perhaps district and county council level, maybe trying to influence an officer to change a report, change their professional advice, so that's not acceptable. Now, at district council level, one of the things that I've done is draft a protocol on officer-member relations. It is a lengthy document for our purposes at district council level, because it needs to be, because of the political dynamics and the attendance of officers at political meetings and that sort of thing. But I would commend it to parish councils to have a look at. Certainly for one parish council, I've assisted them to prepare something like this for that council, purely to try and help any relations within the council. Particularly, I think sometimes in a smaller environment, relationships can break down, people become polarized, and sometimes very difficult to pull that back. So it's something to have a look at. It's really a bit of a manual on how to interact with each other. Makes it very clear that politicians local councillors are in place to determine the strategy and the way that the council should proceed, what you want to achieve. Then officers are supposed to put that into effect, and that works right the way across every layer of local government. So I've already said that any issues with your clerk, for example, should be taken up through appropriate channels, not to have any disagreements and arguments and criticism in a public setting. Apart from the fact it doesn't look good for the council in terms of how it operates. As I said, the officer has no means by which to defend themselves, and there's a proper process that should be followed. And as you know, the clerk works for the local authority as a whole and must be politically neutral. So in terms of bringing this to life a bit, one of the cases which I think probably infamous throughout the Code of Conduct, world of standards and ethical standards, is Sandwell Borough Councillor and former Councillor Hussain. Now, this councillor had essentially taken steps to try to put pressure on officers to cancel parking tickets for members of his family. He had forced officers to sell a building at a knockdown price to somebody that he knew, to a friend of his, and he was found to be in breach of the Code of Conduct. I think Sandwell, which is still rumbling on, even now, many years on, still rumbling on, still a lobby of councillors who think that this particular councillor was hard done by. I don't, for the record. I think that this is probably an example of how to breach virtually every element of the Nolan Principles and of the Code of Conduct. So the only other one I've seen like this is a recent case in Cambridgeshire County Council involving the rental of a farmhouse owned by the County Council. So again, that's in the notes. So, you know, basically officers have a job to do. They're entitled to do that in an unmolested way, and essentially it's about a good working relationship, as we all would like to have in any event. So the next element is confidentiality and access to information. I'm very sorry, it's a busy slide, but it's quite a detailed provision. So you will know, as councillors, you are coming to information which is in your possession, which may be confidential, may be commercially sensitive, and you should not disclose that or use it for any other reason than that which is being given to you. So I'll put some examples on the companion notes where this has applied. Not so much in a town and parish council perspective, I would suggest, because generally, unlike a larger council, county or district level, where members are perhaps members of a particular committee, not necessarily involved in everything. But the general rule is that councillors don't have what the common law calls a roving brief. They have a need to know, and if you need to know something to be able to fulfil your duties as a councillor, then you're entitled to that information. I think things have moved on a bit over the years. Really speaking, the slides will be sent to you after the meeting. So as part and parcel of where we are in terms of disclosure of information, by and by, I think as town and parish councillors, there's not really a lot of information you wouldn't be party to. The only thing I could think of would be perhaps where a finance committee has been delegated authority to let a particular contract, perhaps it's at confidential negotiation stage. Alternatively, and in particularly staffing matters, generally not a right to know there. There may well be sensitive personal information, as you know, covered by GDPR. So depends on the circumstances. If in doubt, have a quiet word with the chair or the clerk, and you know, if you're not entitled to something and there is good reason for it, then I would say you have to take that that explanation at face value. Sorry, you should. Once you have that information, you are restricted from disseminating it, as you can see there, from either by consent, or you're required by law, or it's made to a third party for the purpose of taking legal advice, and sometimes that's legal or financial advice or professional advice. But finally, disclosure must be reasonable and in the public interest and made in good faith. So when I worked at Swansea, well, I did my schooling at Swansea in local government. I think it's fair to say that Swansea leaked like a sieve. So there was very little which would remain confidential in confidential reports. And I remember being quite green coming from the private sector, being confident in the process, doing a confidential report, and then reading all about it in the Evening Post the following night. So that kind of woke me up to the fact that these things happen. So the other aspect then is not to use that information improperly. You should not use it for your own ends. And I can see you thinking to yourselves, well, nobody would do that, would they? Well, I'm afraid they do. Another case in your notes, obviously Cambridgeshire I've mentioned, and that is a very complex case. But we had a case recently where, bear with me a second, I'm just finding my note. Where a councillor who'd been sitting on an external board relating to regeneration of an area in Cardiff, and a company were being considered to take over that site. And armed with that knowledge, although he denied it, that councillor then bought shares in that company on the basis that the information he had is that the company was on the up. So he obtained that information as a cabinet member sitting on that board, and then used it for his own ends. So suffice to say, he was found in breach of the code of conduct and was suspended for his troubles. And just to add insult to injury, he sold the shares and made a loss. So what I would say is that's a real life example here of how these things happen. And as I said at the start, this is quite a dry subject here in part, and that's why, in terms of the notes, I try and find, as I say, some of the worst behaviour out there, just to demonstrate that even though we might think that it doesn't happen, I'm afraid that it actually does. So the next is disrepute. Very, very wide. Basically, I would say this probably is one of the main grounds of complaint under the code of conduct. Excuse me. And what that means is that you could be found to have brought your role as a councillor into disrepute, or the actual council itself. So one of the things I say there, again, not really that much of an issue for you as town and parish councillors maybe, but certainly in county and district councils dealing with regulatory matters, planning, licensing, etc. It's absolutely key that the public have confidence in your decision-making processes. And of course, as a councillor, you're trusted to make decisions on behalf of your community and subject to greater scrutiny than members of the public. So I've already mentioned Sandwell and Councillor Hussain. I suppose my favourite case, even though people sort of frown a bit when I tell them the facts, is former leader of Swansea City and County Council, former Councillor Lawrence Bailey. So Councillor Bailey had a council laptop, and he took it in for repair. And whilst being repaired, the IT bods discovered that he had downloaded numerous pornographic images. I stress all legal, all adult content, but nonetheless he'd downloaded it onto his council laptop. Now, he did that twice, and what they found were 70,000 images on his council laptop. And the reason I like this as a case is because what happened next is they also found 253 documents, which were mostly letters under nom de plume or pseudonyms to the local press, saying what a wonderful job Councillor Bailey was doing for the city and for his ward. So he'd been writing to the local paper, as I say, under the pretense of being somebody else, and he went before the adjudication panel and was disqualified for 2.5 years. Now, I find it deeply ironic. I have nothing particular against Councillor Bailey. He took his medicine and that's that. But I find it deeply ironic that he now writes a weekly column for the same newspaper. But there you go. So closely related to that is you shall not use or attempt to use your position improperly to the advantage or disadvantage of anyone. Now, I've already given you the example of Councillor Poole at Caerphilly. He purchased those shares, but this is equally applicable if you use your position perhaps to give somebody a leg up with something, or perhaps on the other hand do somebody down. And very often you'll find that there are cases where councillors have been involved in decisions regarding somebody, and I saw one the other day, and it's referred to in the notes, where there was a relationship in the past from a family perspective with a councillor who was sitting in a decision whether to co-opt somebody, and quite clearly they should not have been taking part in that meeting. And when I come to talk about interest later on, had a query this week from a clerk as to whether a councillor should sit in a meeting making decisions about co-opting candidates, one of whom was a spouse. So I'll talk to that a little bit later on. But it does happen, unfortunately. So I mentioned Sandwell, I mentioned David Poole. The other one I'd just like to draw to your attention, and again a Welsh case, because again it was reported he was suspended, was the former leader of Merthyr Tydfil Council, Councillor Kevin ONeill. He lived next door to a property which was being sold to a company which provided accommodation for children in care. There was a massive local outcry about this. He was at the forefront of that. Facebook comments, I suppose, prime example of NIMBYism. And of course, as leader, he spoke to the monitoring officer. The monitoring officer said, "You shall not have anything to do with this because of your because it's such a close issue to you." Nonetheless, he attended a meeting and essentially took over the meeting with the company who were going to run this facility. And in the event, they actually pulled out and didn't buy the property. So quite clearly, he'd used his position improperly. As leader of the council, he basically had an access all areas pass. He shouldn't have been in that meeting. He was advised not to, couldn't help himself, and was suspended for 6 months for his troubles. So resources, you're all elected, co-opted, part of your councils to do a job for your community. So you're entitled to use council resources to help you do your job as a councillor without question. So you may have office support, stationery, equipment, phones, computers, access to buildings and rooms. So they're given to you in your role to carry out your, given to your role as a councillor to carry that role out more effectively. But they should not be used for business or personal gain. Must be used in accordance with the purpose they've been provided and your own council's policies regarding use. So some examples in the past, I was asked when I was the monitoring officer in Swansea whether the Liberal Democrat group could bring in something called a risograph. I had no idea what a risograph was, but apparently it churns out leaflets at a rate of knots. So of course they wanted to use it for political purposes, and quite clearly that was not permitted. We had to come up with a fix in the end, and essentially they were charged per copy, and somebody would go in and read the dial on the risograph at the end of every session, so that they would be appropriately charged. That's just an example of it being misused. I've had complaints in the past because a councillor has logged on to their work email while sitting in the council chamber in between meetings, and it is taken to the extreme. Now clearly that is not what this is meant to prevent. So it's got to be within reason, but as you can see there, you're not allowed to use council resources for political purposes. As I say time and again, not necessarily a big issue for you from a town and parish perspective, but clearly if they are used for political purposes, that would be not only a breach of the Code of Conduct, but also unlawful under the Local Government Act 1986. Okay, so I'm going to whiz through, just conscious of time. We've introduced a new obligation, which is that you must comply with the Code of Conduct in terms of training. You must cooperate with any Code of Conduct complaint, shall not intimidate or attempt to intimidate anybody involved in a complaint against you or somebody you know. And most importantly, take your medicine. You must comply with any sanction imposed following a finding that you breached the Code of Conduct. Now, I'm not going to go into sanctions tonight. They are set out in the Code of Conduct, but in essence, as I say, generally it's restriction of access, censure, something being published in the public domain. And if there's ever a case of bullying, then it may well be restriction to access to certain people or buildings. So, right, I'm not going to move on to interests. This is quite a bit to get across, and really probably the biggest change in the code, because we now have, as I'll say in the next slide, 3 types of interest, whereas before we had DPIs. So problem area always in public life is that, as a simple principle, public decision makers must make decisions based on the public interest and not to serve their private interest. The Localism Act requires me to hold a register of interests of members of the authority, and that includes your good selves. But of course, the purpose of the registration is to demonstrate to the public any interest which you have, to demonstrate that you're not going to be caught in conflict with anything. And if anybody wants to look at your interest, then it's there as a matter of public record. I'll talk a little bit about sensitive interests in a bit, but just some starting points. One of the things I always say to councillors is that my job is to enable them to take part in a meeting if it is appropriate for them to do so. So we don't have a, as was the case in Neath Batalba versus Ware, and if in doubt, get out mantra. That's overcautious, was criticised by the court. I have to say in defence to my colleague monitoring officer, who's retired now, lucky him, from Neath, he didn't actually say that. That was just what members had thought they'd been told. But you are personally responsible for deciding whether or not you should disclose an interest in a meeting. We can advise to the clerk, or if you wanted to contact me or Stephen before a meeting, perhaps, we will always offer some advice, but our advice can only ever be mitigation. It can never be exoneration, because only you know. And I'll give you an example at Stroud. Just about to start a meeting on submitting the local plan to the inspector for examination. I have a panicked phone call at 5 to 7, meeting starting at 7 o'clock. Councillor, I've just had an email from a reporter with private eye. What do I do? I said, well, first things first, send me the email. So I had a look at it. An email said, good evening, Councillor so-and-so. I noticed that you're going to take part in the meeting tonight, and one of the candidate sites is the field immediately adjacent to the business which your husband is a director of. So far, so good. I'd already advised her on that. She told me about this. She said, look, this isn't going to affect our business one bit. But then the private eye investigator, who'd obviously done his homework, went on to say, did you forget that the company of which your husband is the director pay you and him in a personal capacity £75,000 a year for use of this site? Now, she hadn't told me about that. Of course, immediately I told her she was not allowed to take part. She had to withdraw from the meeting. But that's the point I'm making, is that, you know, we can't advise unless we're told all the facts. So we now have 3 categories of meetings of interest. I do apologise. So we have disclosable pecuniary interests. You know about those. You had them forever, it seems. I'm going to go through them one by one just to make it clear, so that we know where we are. We then have other registrable interests, and then we have non-registrable interests. Confusing? Yes. Let's break it down and hopefully it'll make sense. I would say at the outset that we are taking a sympathetic view of this. We know it needs to bed in. It's a new way of doing things in many respects. Sometimes it will be absolutely obvious that you have an interest and you shouldn't take part. And I think that should become apparent as soon as you see the item of business. But let's go through them and see if there's anything which perhaps needs explanation. So DPIs, in short, we've had since the Localism Act, so 11 years now. There has been some confusion around when you would need to declare a DPI, and essentially the Localism Act says that a member is required to disclose a DPI that they're aware of at a meeting, or if acting alone, where any matter to be considered relates to their interest. So it prohibits you from taking part or making a decision on a matter if you have an interest in it. Fair enough. So basically, the DPI must directly relate to your registered interest and the item of business. So something which is going to impact you financially directly. So, for example, if you registered 1 Acacia Avenue as your address, you would have a DPI if you put in a planning application for that address, or if the whole of Acacia Avenue was being considered for a resident parking zone. But you wouldn't have a DPI if number 3 Acacia Avenue had put in a planning application, as that matter does not directly relate to your registered interest. But I'll come on to that in a moment, because there may well be a direct impact on you, and as such may be a non-registrable interest. Okay, so let's go on to DPIs. So employment, quite clearly, you have to register your employment anywhere, not just in the district or your town or parish. And that is any office, trade, professional vocation carried on for profit or gain. So it doesn't cover non-executive directorships, for example, which would be unpaid, perhaps any consultancy that you do on a grace and favour basis for a charity, for example. So those wouldn't be covered. If you're a retired professional, that wouldn't be covered. You have to be gainfully employed for that to apply. I'm going to whiz through these. I've split them in. They used to be in 2 slides. I've divided them all up because some of them do cause confusion. So I'm going to go through them, but I'm not going to spend a great deal of time on them. Sponsorship, probably not so relevant for town and parish councils, but it includes any payment made towards election expenses, for example, and also if you're a member of a trade union. But as I say, only if the matter directly relates your DPI. Contracts, any contracts which are made between a body in which you have an interest, or you might have a contract with the council, under which goods or services are to be provided. So if there's a contract, let's say you operate a business in your town or parish, and you tender for some work with the town or parish council, quite clearly that's a DPI. You shouldn't be anywhere near that decision. Doesn't cover contracts which have been discharged. So it's quite clearly the case, if you can influence something which is still potentially going to have an impact on you financially, then you should not take part. Land. Distinction here between employment is that this only relates to the area in which you are a councillor. So if you are a town or parish councillor and you live within the town or parish area, then you have to declare your interest in any property whatsoever. That could be your home, rental property. You might have bought a property for family to live in the area. If you have a beneficial interest, i.e. an interest in the proceeds of sale, you have to declare that. Licenses, generally rare, but I put here includes allotments, because I found in certain areas I've worked where there are a lot of allotments. They're generally run by the parish council, create a lot of dispute in terms of usage, in terms of management, in terms of people not doing what they should be doing. If you have an allotment with your parish council, you should not be taking part in any discussion around that particular allotment. Corporate tenancies, I'm not going to spend any time on this. This is, again, a rarity. Essentially, this includes shops and commercial units. So if you have an interest in any of those within your council area, then you have to declare it. Securities related to shares, bit of a complex one, this, but you'll see it's really about limited companies in which you have a large shareholding. So a couple of hundred shares in BT would not be an issue, so you wouldn't have to worry about that. What I would say, and certainly had one councillor being caught out by this, it does cover things like community interest companies. So you might be aware that you set those companies up, 3 of you with £1 each shareholding. Well, as a result of that, you would then have more shareholding than you would have the shareholding, which would mean that this would be engaged. So you should then register that. A little bit about sensitive interest. If there's any scope whatsoever for violence or intimidation as a result of your work or home in particular, I would say being on the public register, you can ask for that to be considered as a sensitive interest. I'll say it now, I'm entirely sympathetic. I don't think I've said, well, I haven't said no to anybody yet. Okay, under the electoral law, they've now removed the requirement for you to put your home address. Unfortunately, the code of conduct has not caught up. Rishi Sunak and the previous guys wrote to all Montrenorths to say, please take a sensitive approach. I do. So if you are ever worried about that, then I would certainly agree to it being treated as a sensitive interest. And what would happen on the public register, it would say, I have an interest which I have disclosed to Montrenorths, and that would be that. And if it ever cropped up in a meeting, you wouldn't have to declare what that sensitive interest was, for the obvious reason it would completely undermine the purpose of having the sensitive interest withheld. It does happen. However, what I would say, having recently got in a bit of family genealogy, I was staggered at the amount of information I was able to gather online. So we're saying goodbye to Gran Canaria because supper is calling. So enjoy the rest of your holiday. Right. So if you have a DPI, you don't take part. Simple as that. You're not allowed to take part in a discussion, vote, or remain in the room. You must leave and come back in when the matter has been concluded. Any questions on DPIs? Okay. Right, so go on to other registrable interests. So in terms of your DPIs, it's very straightforward. Other registrable interests, now this is a new category which has been implemented. A lot of councils actually did have something like this informally in the past, but this now puts it onto a formal footing. So as the slides say, I've highlighted the key areas. So you have a personal interest in any business where it relates to or is likely to affect. So quite clearly anything relating and likely to affect that. So as you can see there, unpaid directorships, any body in which you're a general control or management or nominated by your authority and nominated by your authority. Again, might not be the case for town and parish councils, but this is key then. Any body exercising functions of a public nature, directed for charitable purposes or influencing public opinion. Thank you very much to a colleague, Clark, who pointed out to us that when we'd put this together, we conflated that last red sentence with C, so it looked as if it only applied to C. It applies across the board. So if you're a member or position of general control or management, you must declare this as another interest, and that works. If you're a district councillor, you must declare your parish council, and likewise, obviously, in your register of interest for a parish council. If you're a district councillor, you disclose that as well. Also includes school governors, for example. So clearly, you are in a body exercising the function of a public nature, and as a governor, you are in a position of general control or management. So school governorships have to be declared as well. So that's what you look at. So you look at that, that's registered. If you have, if an item of business comes up then which relates to the other registrable interest, it's not just financial and personal to you, it also includes financial interest or well-being of that organisation or entity. And I've had, just to give you an example, I've had permission from the council to mention a case that we recently concluded. I'm not going to go into the detail because it's still a little bit sensitive, but I'll just explain. So this councillor took part in a committee, and he is an academic, and it was suggested that as an academic he had a particular affinity for universities generally. Somebody's trying to take control of my slides there. Hands off, please. And as a result, shouldn't have taken part. So quite clearly, what we said, well, he had no interest in that entity, either on a financial level or in terms of its well-being. It wasn't a close associate of his. So that's the test, really. And as I say, we will take some time to get to grips with this, but you must declare to the meeting, either at the declaration stage, and sometimes it might occur to you as you are going through the business, and you might start talking about something divergent to something, and then occur to you of an interest. You must declare at that point. So if you have an interest and it is going to be directly linked to the financial or personal interests of your associations, then you may speak if members of the public are allowed to speak, but you shouldn't take part in a discussion or vote. And I think that's fair enough, isn't it? If you have to draw the line and say, well, actually, it wouldn't be proper for me to take part in that, because quite clearly the public would say I can't make a decision in the public interest here. So you mustn't remain in the room unless you've been granted dispensation. Dispensation would be granted by your clerk. I would say that the circumstances where a dispensation would be granted to town and parish councillors would be rare. But generally, if it would mean that a decision could be taken because everybody had an interest and it wouldn't be correct, then the doctrine of necessity applies and the clerk would give a dispensation, because otherwise the decision couldn't be made. As I say, rare. Any issues, quite clearly, I'd be happy. I've always said happy to speak to clerks or chairs about this. What does well-being mean? It's on the slide. I'm not going to read it out. Very wide-ranging. This is something that was formulated by the then Standards Board some time ago. So not just financial, also well-being. So might affect, and the example I gave earlier on might affect the well-being of a councillor to vote to have their spouse onto the council. Also affect the well-being of their spouse. Depends on their relationship, I guess, but there we are. Okay, so non-registrable interests. Right, so this is where it gets slightly complicated. Those of you who've been around for some time will remember the old school, old money, personal and prejudicial interests, and I think this is probably back to the future in relation to these interests. So a non-registrable interest, something which directly affects your financial interest or well-being, which is not a DPI or other registrable interest, or the financial interest or well-being of a relative or close associate. So let's break this down. So where a matter arises at a meeting which affects your own financial interest or well-being. So under A, if your son has submitted an application for a license to open a bar, the matter directly relates to your relative. You must not take any part in a discussion or vote on the matter. Fair enough? Financial interests or well-being of a relative close associate. As I said earlier on, it may well be that there are family connections, and of course that wouldn't be a DPI or an other registrable interest. They would be covered here. But as another example, under B, there's been an application to build several units of housing on a field adjacent to your business partner's home. It's not their application, but they will be more affected by the application than the majority of people. So again, you would be expected to declare that interest in withdrawal. Similarly, an application for a property next door to you, as I said earlier on, does not directly relate to your property, so is not a DPI, but would be a non-registrable interest. I've taken the view in the past, depending on the impact, that because we didn't have this regime, I've erred on the side of caution and said that councillors should declare if their property was affected. Now we have this regime, it would be covered by this. So just to give an example, I had a very long conversation with a particularly irate councillor who had been told not to take part in a planning matter. And of course, you don't make decisions about planning matters at your council. You give very clear indications as statutory consultees to the local planning authority. Now, this councillor had on the planning portal put a formal objection into an extension on a property adjoining his, and he had said specifically that the erection of this extension would directly impact on the use and enjoyment of his garden. He couldn't see, despite quite a long conversation, that it was problematic for him to take part in any decision around this. And as I said to him, as a matter of public perception, just look how this would be played out on the front page of the local newspaper, for example. Councillor takes part in decision in relation to property which is going to affect his. So that's why we have this type of interest now. And again, just as an example, planning permission for land next to a school, of which you are a governor, would be covered. So say traffic would be greatly increased. So of course it would have an impact on the well-being of that school of which you're a governor. So you must declare at the start of the meeting, or as I say, as soon as you realise that you have an interest in the matter. So this is where it gets a little bit complicated. This is where I refer to the old money personal and prejudicial interest. So you might have a personal interest. We then go on to adopt this test. So this is where either the monitoring officer or the clerk will be there to guide you. So where it does affect your financial interest or well-being, it has to be to a greater extent than the financial interest of the majority of inhabitants of the ward. So in a district council sense, that's why council tax isn't covered as an interest, because you're not any more or less affected than the rest of the members of that district or patch. Likewise, when you're voting on a precept, not an interest. Okay. But then we go on to say, well, would a reasonable member of the public, knowing all the facts, believe that it would affect your view of the wider public interest? So this is where the prejudice comes in. Are you, on an objective viewing, incapable of making a decision in the public interest because you're so closely intertwined with the decision in hand? Now, if that is the case, and you have this, you have what I call the prejudicial interest, you may speak only if members of the public are entitled to speak, and then you must not take part in any discussion, vote, and leave the room. So that's where it is with that. So under the new regime, we have asked you to complete new register of interest forms, because there's an obligation now for you to register your other registrable interests. I do apologise, and after the next elections, we'll be doing the whole system again. It's very clearly the case that we have to maintain a register which is up to date. So I apologise to be a bit of a pain with this, but we do have to ask that. A couple of slides on dispensations. I'm not going to go through those now because of time. Any queries you can ask your clerk about this, but I've set out on the slides the circumstances in which you can ask for a dispensation. So just to start to finalise, questions you need to ask yourselves, and these are my questions posed for you to consider. Have I got an interest or stake of any kind in the outcome of a matter in discussion? If I find of an interest or conflict, what should I do? Would an objective third party, knowing all the facts, think that the interest is so significant that it would affect my judgment of the public interest? And if they think if they would think it might affect my judgment, what do I do? Well, first things first, you take advice. You speak to your clerk. If necessary, you or your clerk could speak to me or the deputy monitoring officer. We're always happy to give advice. The way I describe it is I would rather spend 10 minutes giving advice upstream than dealing with a code of conduct complaint, which takes me 10 hours downstream. So I'm very happy to invest the time. Only you know whether you have an interest. Take advice as far before the meeting as you can, if possible. It allows you to discuss it in private and to reach an informed decision. There's nothing worse than trying to get to grips with an interest when everybody's sitting waiting for an item to start. The public are there, and certainly as monitoring officer, I liken it to be sometimes being in Who Wants to Be a Millionaire, because the questions asked of the monitoring officer, it feels like all the lights are on you and you have to give advice in that moment in time. Far better to discuss it beforehand. Always remember that the reputation of the council as a whole is the one that is affected by your decision. And depending on the issue, and I suppose at a local level, neighbourhood plan is probably prime example for judicial review. You know, if you're biased, if you're found to have an interest, then quite clearly that would be a ground for judicial review. And all the hard work you've done in putting together a neighbourhood plan wouldn't be undone, because what it does is it strikes the decision out, but it puts you back many months and costs you many tens of thousands of pounds. So that's when it becomes real in terms of the legal process and the impact on your council. So failure to declare can damage public trust, and as I say, there's a lot of time and resource consumed dealing with complaints or challenges. Take it from me, I tend to put a lot of legwork into complaints and certainly determination letters, because I know that the member of public needs an explanation in detail, and also that the local government ombudsman is entitled to look at the way I've exercised my discretion to deal with complaints. So there is always a lot of time invested in dealing with a complaint. I'm not going to talk about gifts and hospitality tonight. The slides are there for you. It is a new part of the code. Certainly at district level, it's something I wanted to introduce into the code of conduct so that we had a clear benchmark. So I'm just going to say top tips from me. Again, looking at the time, consider your interests now and always update them as things change. I did encounter previously this mindset, well, I declare when I am elected, I've done my bit. No, it's an ongoing duty. As far as I'm concerned, your interest should reflect your true position in as close to real time as possible. So if you move address, if you change jobs, if you buy shares, if you have an allotment, you should register that within 28 days. Sorry, this is a little bit like telling you to suck eggs, but read your papers carefully and try to anticipate any decisions or matters in which you might have an interest. Seek advice as possible if you're not sure. It doesn't hurt to ask and saves potentially a lot of issue later on. Only you know whether you have an interest, but the point I would make is, you know, we want you, where appropriate, to be taking part in local democracy. So err on the side of caution without being overcautious. So that's the end of the presentation. I'm more than happy to answer any questions if anybody has any. I'm conscious that these are quite late in the evening. I put them on at 7 o'clock to make sure that everybody can attend and get away from work and deal with family commitments. But I'm also conscious that you might have better things to do for the remainder of the evening. So I'm here to answer any questions if you have any. Feel free to email in afterwards if you want to. So Michael May first, please.
Thank you for that. I think you said earlier on that training was sort of mandatory. Does that mean that every councillor has to attend a session like this, or can they just actually read the slides?
I'm gonna say watch the recording. So I realise that this may not be convenient to everybody. That's why I record it. There's another session at the end of October. Tonight now we have on the call, excluding Stephen and myself, 47 councillors. That's a fantastic turnout. So, but they will be recorded. I would say reading the slides, you're not going to get the level of information that I impart, because what you can't see with the slide deck is I have all of my notes alongside the slide, and I talk to those as we go. Also read the materials that we send out. You know, I will say that it's you know, it can be a little bit dry, but I try and make it as entertaining as possible. So watch the recording. Just reading the slides, I don't think you get enough from that. Councillor Robin Williams.
Yeah, no, I didn't have a question as such. I just wanted to thank you for what I thought was a succinct and a wrong word, but a beautiful presentation. Thank you very much. Much appreciated. A lot to digest, but I think your slides will certainly help that. But thank you. It was much appreciated.
Thank you very much indeed. Michael May.
I suppose the only thing is, I mean, on the form, the new form, it specifically to identify spouse, civil partners or equivalent. So you're supposed to identify registered interests. But then in the text of the explanatory notes, it says there's no requirement for the notification to show which interests arise via your spouse or your partner. It seems to slightly contradict the change that you've made to the form. Surely you don't need a column that says spouse, civil partner or equivalent. You don't need to identify which is which.
I'll pick that up with Stephen tomorrow. We look at the form. Sorry, I'm got it in front of me. We had an issue previously where councillors were not declaring interest of their spouse or civil partner. So we've introduced that. But I'm sorry I haven't got it in front of me, but I'll certainly undertake to look at that tomorrow and make sure that if there is any contradiction, we sort that out. Any more questions? Well, I'll leave it there. Thank you all very much indeed. I really do appreciate you taking the time to come out, even though I've now made it part of the code of conduct that you need to come out. But if anybody wants to watch the recording, we'll make it available on YouTube, and to make sure that we get the coverage for everybody, we'll send it to the clerks at each of your respective councils. They can let you the link. But thank you all very much indeed. I really do appreciate it, and it is nice to get in front of you and actually give you a face to a name and let you know how I deal with these matters. So thank you all very much, and I wish you a really nice remainder of your evening.